11th Amendment was passed by Congress on March 4th, 1794. It was later ratified on February 7th, 1795. It says that U.S. judicial power will not be used for any lawsuit across state borders. As an example, a person from Montpelier, Vermont cannot sue a person from Concord, New Hampshire. The 12th Amendment was passed by Congress on December 9, 1803. It was later ratified on June 15, 1804. It says that the President and Vice President of the United States of America must be clearly identified. Usually, the person with the most votes for president is president, and the person with the most votes for vice president is vice president. If there is no majority, the top candidates are voted upon immediately by the House of Representatives. In order to win, the candidate must get 2/3 of the House's votes. If there is still no president before March 4th, the vice president will act as the president. If there is no vice president, the top two candidates will be voted upon by the Senate. 2/3 of the votes of the Senate will be needed in order to win. A candidate that loses as president cannot become vice president. Amendment 13 says that there is to be no slavery in the United States of America. Only as an extreme punishment can one be put into involuntary servitude.
Another of the three constitutional Reconstruction amendments, the 14th Amendment, is aimed at establishing political equality for Americans of any race. The amendment was ratified on July 9, 1868, and provides a definition of a citizen of this country stating, "All persons born or naturalized in the United States are citizens." It is basically proclaiming that all men will be treated equally. This amendment promotes Thomas Jefferson's opinions in the Declaration of Independence that all men have the rights to inalienable rights, including life, liberty, and the pursuit of happiness. The amendment addresses citizenship rights and equal protection of the laws, and was proposed in response to issues related to native-born former slaves following the American Civil War, whose rights were being denied. The amendment was bitterly debated over, especially by Southern states, who were eventually forced to ratify it in order for them to regain representation in Congress. Anchor babies, or children born after a mother briefly crosses the border to give birth, created controversy as well. The amendment has been used to make states enforce the Bill of Rights, and it was the base of Supreme Court cases like Brown v. Board of Education, which integrated schools, as well as legislation like the Civil Rights Act of 1964. Another Reconstruction amendment, the 15th Amendment, granted African American men the right to vote by declaring that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Before the Civil War, all African Americans, former slave or not, had not been given the right to vote due to the Supreme Court case of Dred Scott v. Sanford, which established that African Americans weren't citizens. This law was in effect until the 15th Amendment. Although ratified on February 3, 1870, the 15th Amendment would not fully take effect until the Voting Rights Act of 1965. After the amendment was originally passed, white Southerners who wanted to reassert their power used poll taxes, literacy tests, and other ways to successfully disenfranchise most African Americans. One of the shortest amendments, the 16th Amendment, ratified on February 3, 1913, deals with a word almost everyone hates: taxes. It states that Congress will have the power to lay and collect taxes on incomes without regard to the population or census of any of the states. Seen here is the first page of the Income Tax Form 1040 from the United States Internal Revenue Bureau. It works so that the more money you make, the more you are taxed. This money then goes to the federal government.
The 17th Amendment to the United States Constitution is one that determines the manner or system in which the United States Senators are to be appointed. It also provided for a term length for senators, as well as procedures to be considered in the event that the state had a vacancy in the Senate. The 17th Amendment was proposed in May 13, 1912, with Connecticut being the last state needed to complete the ratification on April 8, 1913. From that date forward, all United States Senators would be appointed through a direct election by popular vote. The 17th Amendment proposes that the Senate will be composed of 2 senators from each state. Each senator is to hold the position for 6 years. Each senator of the state will have 1 vote in the case that a vacancy in the Senate in any state arises. The governor or executive authority of that state has the right to fill in the vacancy by appointing a replacement through a popular vote. Before the 17th Amendment, a governor had the authority to appoint a replacement of his choosing on an immediate basis. The appointed official would have to meet the requirements of such office and would only serve until the next legislature would meet. One of the reasons that the 17th Amendment was adopted as one of the constitutional amendments is in direct relation to the vacancies in the Senate existing for long periods of time. The election of senators would often be deadlocked due to different parties holding control over different houses, and their political interests would be a matter of conflict. Before the popular vote election system, senators would be appointed, and over several situations arose where officials would be appointed through the influence of outside factors, such as bribery and corruption were also a concern. Therefore, it became more apparent that the senators should be elected by the general populace of the state. The 18th Amendment is the only amendment to be repealed from the Constitution. This unpopular amendment banned the sale of drinking alcohol in the United States. This amendment took effect in 1919 and was a huge failure. Not only did regular people find other ways to drink alcohol, criminals made a lot of money selling alcohol to those people. The 21st Amendment repeals the 18th Amendment in 1933, and today we call the period that the 18th Amendment was law prohibition. The 18th Amendment was not always unpopular, in fact. Some states had already banned alcohol before the 18th Amendment. Before the 18th Amendment became a law, religious activists, famous women, and also some men blamed alcohol for violence and other problems that were affecting American families. They would take axes and other weapons and attack saloons or other places that stored alcohol, destroying it all. The motivation for the 18th Amendment was inspired by these activists and their desire to make a better society by outlawing alcohol. We know now that the 18th Amendment failed and in fact made things much worse. The effects of the 18th Amendment were that Mississippi was the first state to accept the amendment in 1918, and New Jersey was the last in 1922, at number 46. By then, the majority had already been reached. After the 18th Amendment, Congress passed the Volstead Act, which set the date for prohibition at January 17, 1920. This act also defined strict limits on beverages containing alcohol, ensuring that the content will be no more than 0.5%. The Volstead Act contained the provisions to enforce the 18th Amendment on Americans. This act did allow for some alcohol to be kept as medicine and for research, but this was often exploited. The 18th Amendment gave rise to the gangsters of 1920s that made a huge profit selling illegal alcohol. Such was this disaster, and the government would finally agree to get rid of the prohibition in the 18th Amendment 10 years later. The 19th Amendment is a very important amendment to the Constitution, as it gave women the right to vote in 1920. Before the amendment, women could be heckled, jailed, or even physically abused when they tried to vote. Achieving women voting was a lengthy and difficult struggle. Women would have parades to promote women voting, and they even lectured and wrote about their suffrages or the right to vote in political elections. Women also practiced civil disobedience against the government. The 19th Amendment considered radical change to the Constitution, and only a few of the supporters lived to see the women's final victory in 1920. You may remember that the 15th Amendment made it illegal for the federal or state government to deny any citizen the right to vote. For some reason, this did not apply to women. The 19th Amendment changed this by making it illegal for any citizen, regardless of the gender, to be denied the right to vote. The movement to allow women the right to vote through the 19th Amendment was the suffrage movement. You may have heard of women such as Susan B. Anthony and Elizabeth Cady Stanton, who were the key figures in the suffrage movement. The suffrage movement has been going on since the Civil War, but the 13th, 14th, and 15th Amendments did not cover the rights of women to vote. These women were the original authors of the 19th Amendments. Although it took 41 years before the government would even consider ratifying the 19th Amendment, many lawmakers feared that the women would vote in large groups and that would affect the outcome of elections. The 19th Amendment unified suffrage laws across the United States. Before the 19th Amendment, there were many states where women had full suffrage, including New York and most Western states. Other states had limited suffrages, only allowing women to vote in select elections. During this time, there were a number of efforts to get Congress to consider the 19th Amendment. Mostly successful until 1919, Wisconsin was the first state to approve the amendment, and the 36th and final approval needed to have the amendment passed was in Tennessee in 1920. With the ratification complete, the 19th Amendment became part of the Constitution on August 18, 1920.